Good evening, everyone. Welcome to the West Hollywood Planning Commission. This is Thursday, March 15th, 2018, and this is a regular scheduled meeting. Calling it to order. And the next item is Pledge of Allegiance. James Mills, would you come forward and lead us, please?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Secretary, can you please do the roll?
Good evening. Tonight, Commissioner Guy is absent, so the voting record will reflect that. Commissioner Hoopengarner?
Present.
Commissioner Carvalero?
Here.
Commissioner Bass?
Here.
Commissioner Elchel?
Here.
Vice Chair Jones?
Here.
Chair Buckner?
Present.
And we have a quorum.
Thank you. The next item is approval of the agenda. Commissioner Bass, I think you have...
Yeah, I would like to pull item 9B from consent.
9B from consent, okay. We will hear that then before the public hearings. How about item 9A? Is everybody okay with leaving that on the consent calendar? Yes. Okay, then.
I'm sorry, just a question for legal. If I have a question about it, do we need to pull it, or can it stay on consent?
Well, since we're pulling the other one, you might as well just pull it. You can ask your question, bring staff up, and we can handle those too.
Okay, then I would pull it.
Okay, so we're going to pull both of those, item 9A and 9B, from consent, and they will be addressed before the public hearings. Other than that, do I have a motion to approve the agenda with that change?
Somebody didn't.
Who didn't?
It's me, I'm sorry.
Thank you.
Thank you. And motion passes unanimous.
Thank you. Then let's go on to 9A. And I believe, Commissioner Hoopengarner, you had a...
Chair, we need to do approval of the minutes for the continuation.
Yes,
first.
excuse me. I'm moving forward. There are no minutes from the last meeting. The recommendation is to continue the minutes for approval on to Thursday, April 5th.
Without objection.
Without objection.
They're continued.
Okay, thank you. We'll do that. Thank you, Mr. Secretary.
Thank you.
And we'll go now to public comment at this time. General, do we have any speakers?
We have one, Rick Abrams.
Okay. Mr. Abrams, will you come forward, please?
Abramson.
Abramson. And thank you for being here. I haven't seen you in a while.
Yes, good evening, Commissioners and Chair Buckner. I had two items I wanted to discuss briefly. One is sort of a comment and one a request. So first comment is that Commission and now Council has adjusted the procedure through which projects will be going forward. And if I'm understanding correctly, multifamily projects, R4 zone, 10 units or less, R3 zone, 6 units or less, will be going through staff level review. The Commission will not be looking at these anymore. I would just want to get a clarification to ensure there was no oversight, but R2 zoned properties, which are really 3 units maximum, I don't know if they were addressed in that new protocol, and if so, great. If not, I don't think we want 2-story, 3-unit projects coming to the Commission if 4-story, 10-unit projects are not. So if we can just get some clarification from our manager or director on that, that would be great. And as a kind of corollary to that, when we have changes in the community that are this substantive, I think we need to go another step further to communicate with the public about these new policies and procedures. So it would be great if we could get some sort of handout at the public counter that relays to the applicants and the community how these are going to work. My understanding is if there's any sort of discretionary request, such as a variance, for example, it would still come to the commission. If it's a modification, it would not, because that doesn't require findings. If there's a bonus request or some other deviation, it would come to the commission. Perhaps I'm not correct, but it would be great if we could have real clarity about where those thresholds are, which projects will be reviewed at the staff level, which projects will be coming to the commission, and when there is a map involved that will come to the commission, that my understanding is it's the map only, and what that process and procedure will be. Will there be hearings? Will it be consent? Anyway, if we can just clarify, because this is really new for us, that would be great.
Okay, this did come before the commission and also went to council, but I think Rachel can do some clarifying now if you would prefer.
Thank you.
Sure, thank you for your comments. First, we will have some handouts that will clarify all of those requirements that were just recently enacted by the City Council. So the new requirements are that all R1 projects, all R2 projects, all R3 projects with 6 or fewer units, and all R4 projects with 10 or fewer units can be administratively approvable for the development permit. The City Council also approved a change that would allow subdivisions to be reviewed separately from those development permits. So if a development permit meets the administrative approval threshold, that development permit would be administratively reviewed by staff, and then the subdivision would separately come before, like tonight, come before the Planning Commission for typically a vesting tentative tract map for typically condos or some other land subdivision. In the event that the development permit is something that would need to go before commission review, if the subdivision has been, the subdivision application was submitted at the same time, both of those items would come together before the Planning Commission the same way that they had previously.
Okay.
Can I make a comment about that?
Yes, go ahead.
Can we make those handouts available for a period, I don't know, maybe a year, at meetings as well? Is that possible, in addition to at the public counter at City Hall?
Absolutely.
Great, thank you.
Thank you.
Are they ready and prepared now, those handouts? Are they ready to go?
Yes, typically what we do in this circumstance is give people a copy of the ordinance that clearly shows the language change, since it's not already identified in the codified version online. That does take a little bit of time for the codifier to catch up, but we can have a separate handout, and then we're also working on amending the actual application forms that give detailed information about development permits and where the review is. And I did just want to speak also to the requirement and thresholds for Planning Commission review when an applicant requests an incentive for the density bonus. Should they request any increase in height or any other incentive, meaning kind of the unlisted items, that would automatically kick that development permit to the Planning Commission for review. And if they request any of the other incentives that are listed in the list of incentives, those projects would then go by the thresholds identified in the development permit table for review. So if it was a 4-unit building that requested an incentive that was not in the other category, it could still be administratively approved or reviewed rather. And if they were requesting an additional story or any other concession, then that, regardless of the number of units, that would always come before the Planning Commission.
And any request for a variance would also come.
Of course, no matter what, variances are always reviewed by the Planning Commission. Modifications could be reviewed on a staff level.
Okay, I hope that clarifies it for all of you and for those at home as well, at least for right now. Okay, is there any other speakers at this time? Okay, then we'll move on to the items 9A that was pulled from consent. And is this
Chair, we have the director's report.
Oh, sorry. I'm moving on. Sorry, John.
Good evening. I'm John Kehoe, Interim Director for Planning and Development Services. You might hear that we're using the term Planning and Development Services because our department's name has changed recently. It's now Planning and Development Services, but it still consists of long-range and mobility, current and historic preservation planning, and building and safety. So it's the same divisions with a new name. I just wanted to point out a couple of items that are on the city council agenda for Monday. Two of them are items that were before the planning commission. So item 3A is the zoning ordinance changes for the electrical vehicle parking spaces. So we're moving on with the planning commission's request, with the way the planning commission adopted the ordinance, and with the request that the city council consider making it a mandatory requirement. So that's in the report that's going to the city council. The other item, 3B, is the billboard project and hotel renovation for the building at Doheny and Santa Monica Boulevard at 9091 Santa Monica Boulevard, and that's going forward with the recommendation as by the Planning Commission. And then on the consent, and then on unfinished business, item 4A, there's an analysis of live-work facilities and home businesses, so the commission may want to take a look at that item. That's kind of a research item that the council asked for. Also, I want to just give time to our city attorney to talk about a recent court victory her office had. So I'd like her to mention that real quick.
Thank you, Mr. Kehoe. We received notification just yesterday that we finally got a final decision in a case that has been pending for many, many years, that this commission had recommended approval of, which was the Melrose Triangle case. This commission recommended approval, and the city council approved the project maybe back in 2012. And the project was challenged, arguing that the EIR for the project was inadequate. And the main issue in the case was whether the city's analysis of the historic building on the site was appropriate, and whether the alternatives analysis was appropriate. And the trial court had agreed. The decision was appealed. It took a very long time to get a hearing before the Court of Appeal. I don't know why. We argued that last September, and we received a decision later that month that the Court of Appeal had agreed that the EIR was adequate. Subsequently, the case was published, which means it can be used as precedent moving forward in other CEQA questions. And some interested parties who were very interested in this decision asked the Supreme Court to depublish it, meaning that it couldn't be used as precedent moving forward. And so many interested parties submitted letters for and against publishing and depublishing the case. And just last night, we found out that the Supreme Court agreed not to depublish it and not to review it on their own motion, because they always have the authority, if they think the decision is wrong, to review it also. So after many years, we received our final decision in that case last night.
And in this case, it's gone through all of the courts, through the whole process, and it was affirmed at each level.
Yes.
Thank you. Any more? Anybody else? No? Okay, good. Thank you for that. Now, we're going to go to items of by commissioners at this time. Anybody? Okay, seeing none, then we'll move on to 9A, and that is 217 Housing Element Annual Progress Report. The subject, we were to receive the draft, but I understand there's some question about that. Is that correct? Is this Lynn?
Yes, I wanted to thank Peter for correcting the table as published in the agenda. And I think it's important that we note that of our 10-year goal here, we have a goal of 33 very low, and moderate income housing units for the city of West Hollywood. And halfway through the process, we've already provided well over 120, 130 more than that housing element. So I want to say sort of kudos to the city, our predecessors, our colleagues, for some accomplishments in the housing arena. That's not including the 1,000+ units in excess of our above moderate income levels. So that puts the entire city, 1,172 units, over our housing agreement, if you will, with the state. And so I think as much as we talk about housing and we don't have enough housing, I think we need to honor all of our team about how well they've done in terms of providing housing way above and beyond the expectations. But But related to that, I do want to make a comment and a question. The community outreach piece of this. The 3 dates, 2 of those 3 dates were scheduled exactly opposite the hearings of this body. And so there are hearings about housing, which is directly germane to this body, and yet the community meetings were on February 1st and February 15th, which were exactly at the same time as this body was meeting and having hearings. So I would like to encourage staff to make sure that those meetings provide an opportunity for people to participate in the housing conversations throughout all the things that are going on in this city. And I'm given that those were the 3 meetings, and 2 of which precluded members from making a choice, citizens from making that choice, that's a bit of a concern to me. So I'd like to encourage staff to improve that outreach, and in particular, be a little bit more proactive about reaching out to citizens who've historically proven to be interested in this and not just a general publication. I, for one, don't go to the city website every day to check on what's going on. So if I don't get an email, I don't know about these events happening. Those were my comments on this. Thank you.
Okay, so basically you would ask staff to be careful not to schedule those public hearings or meetings in conflict with Planning Commission meetings. Thank you. And then with regard to 9B, I believe Commissioner Bass had an issue with that wanted to address the public.
The reason I pulled this is you'll see in the report that there was a working group, and I was this body's appointee to that working group, and I found that the staff report does not describe the meetings that I attended, and so I just wanted to kind of raise that I feel as though there was inadequate. The report suggests that there was community stakeholder input, and I don't feel like that really actually happened. I sat through 2 of those meetings, and then I declined to go to the 3rd, and I believe Commissioner Hoopengarner, as the alternate, attended the 3rd, but I don't know how that went. And then when I was driving here, I received an email from the chamber, and I believe all of you got that as well, suggesting that they also feel that there was not a sufficient stakeholder engagement on this. So although this is a receive and file, I just wanted to go on record that I don't believe that there was stakeholder involvement from my perspective on preparing this document. I don't have a problem with what's in there. I actually kind of like it, but I am one voice, and I like what staff has come up with, but I had to object to that description.
Was there, you were at 2 of the meetings, right?
2 of the 3.
And there were no other?
There were other people there, yes, but the record, what I read in the staff report is not the meeting that I recall attending.
So
I don't believe it accurately
reflect what
depicts. It doesn't
happened.
reflect what I believe happened, correct.
And I attended the 3rd meeting, having not attended the first 2 meetings, so I was at a little bit of disadvantage walking into the last meeting. But the outcome that I heard of the final meeting was that the body did not feel that the process was done and that additional meetings should occur, and specifically that was requested by the chamber. But a number of us, myself included, that felt that this was a good start, but that it needed additional work before it moved forward.
Did you want to?
Yeah, if I can just provide clarification, that this is very much intended to be the start of the process. What the commission is receiving tonight is an update on the status of where we are currently with developing the policy. We did have an initial conversation with the chamber today and look forward to having additional conversations with them, as well as continuing to reach out to the working group. We sent an email, I think, yesterday asking for some additional input and look forward to scheduling additional stakeholder meetings. So this is by no means the end of the process. It's a
This
midpoint.
isn't the final report.
That's correct.
This is just a progress report to make the commission aware of what's going on. Is that
Yes,
correct?
that's right.
Okay. So with that, do I have a motion that we receive and file these 2 reports with those comments? Somebody want to make a motion?
Motion is unanimous, noting Chair Guy absent.
Okay, so moving on now to public hearing 10A. This is an appeal of the 8500 Sunset Boulevard West Tower. We're going to hold a public hearing to consider whether the zoning interpretation, our interpretation of whether it's dwelling units or being used as a hotel are not being rented on a long-term basis and are not being used as approved in contravention of a zoning ordinance. So we have a staff report. We're going to proceed as we generally do with a public hearing. We'll have a staff report. Then we'll have the applicant come forward, have 10 minutes to address the commission, and then we'll open it up to public speakers on the issue. Appellant, excuse me. I'll call him appellant. That's right, we're appelling. So thank you for the comment. So Rachel, are you the staff person that's going to do this?
I am. Good evening. Rachel Diamond, Senior Planner in the Long Range and Mobility Planning Division. Tonight before you, you have an appeal of a zoning ordinance interpretation. This is actually the first appeal of a zoning ordinance interpretation, I believe, at the City of West Hollywood. And essentially what this is a de novo hearing that addresses whether dwelling units located in the West Tower of 8500 Sunset Boulevard, which we typically call Sunset La Cienega, one, are being used as a hotel, two, that they're not being rented on a long-term basis, and three, that they're not being used as approved in opposition to both the zoning ordinance and their entitlement documents, which includes a development agreement. So essentially, staff is recommending that you listen to the presentation, take in all of the evidence that's presented before you this evening and also in your packets, and also to essentially deny the appeal and to affirm the director's zoning ordinance interpretation and find on a de novo basis that in contravention of the zoning ordinance, the applicable development agreement and entitlements, again, that the dwelling units are being used as a hotel, they're not being rented on a long-term basis, and that they're not being used as approved. So there is a ton of information before you this evening. Staff essentially issued a zoning ordinance interpretation that was then appealed, and there's a number of back and forth letters, as well as a staff report that gets into a lot of the legal details. So what I really wanted to do with my presentation this evening is keep it really simple. I think all of the facts are before you in writing, and certainly I'm available for questions, but I really wanted to boil this conversation down quite a bit to really get at the crux of the issue here. To give you a little bit of background, Sunset La Cienega was previously known as Sunset Millennium. There are 3 parcels, the east, middle, and west parcels. In 1999, there was a development agreement approved that essentially laid out the development of all 3 of those parcels. Ultimately, as part of that development agreement, the west parcel was the only parcel that was actually constructed as part of that 1999 development agreement, and that's the property that has H&M and SoulCycle on the property. At the time, the middle parcel and the east parcel remained as is and did not get redeveloped as part of that agreement. In 2005, the City Council approved an amended and restated development agreement, as well as certified the associated environmental impact report and the associated entitlements, including development permits, demolition permits, tall wall and sign permits, and a slew of other things that are also included in your supplemental packet too, but have been readily available on our website for quite some time. In 2012, there was also an amendment to the approval that, among other things, wanted to clarify that while there was a vesting tentative tract map that condominiumized each individual dwelling unit that was approved as part of the 2005 development agreement, that those units could also be used as apartments. So ultimately, when a final map was approved by the City Council, that map subdivided the property into, I believe, 5 parcels. The parking was one, the commercial was another, the towers, and I'm missing something here, some of the common element, but essentially, rather than condominiumize each individual unit, the 2 residential towers were essentially in blocks that could then be rented out as apartments. Again, all part of the clarification in 2012. In January of 2017, there was a certificate of occupancy issued for the project as a whole. There was 1 permit for the core and shell of that project, and 1 certificate of occupancy was issued. At that time, then all of the individual property owners and tenants started to to take ownership and utilize the spaces, and then got tenant improvement permits to then further build out their spaces, some of which are now open, such as Fred Siegel, which is one of the ground floor commercial spaces being utilized. Others are still under construction. There's a restaurant that's under construction today, a boxing gym, and a number of other uses. In June of last year, the city was made aware of not only the sale of the residential portion of the property from CIM to the group that is part of the appellant group, BPREP 8500 LLC, excuse me, but also the LA Times article that alerted the city to that sale, which is included as one of your attachments, also alluded to the operation of the space as essentially an extended stay hotel. The operator of the residential, AKA, was kind of highlighted in that article and essentially, again, alerted the city to that issue. So ultimately what the city did was reach out to the operator, and you have a letter from the city manager in your packet as well, to kind of understand further what was going on, but also to notify the operators that their potential operation of the site would not comply with the zoning ordinance and with all of the approved entitlements that were provided for this property. So with a little bit of back and forth, again, with all of the letters provided in your packet, there was a zoning ordinance interpretation issued in November of 2017. And that was issued by the director, John Kehoe, and that zoning ordinance interpretation was then appealed by the appellants in December in a timely manner. So that brings us to where we are today, essentially. And again, as I said previously, I think that the appellants provided a number of letters to the city, and those are addressed both in the staff report as well as in other documents. I really just want to boil this down to, really, well, it wasn't so few, but 6 items to really talk about here. And just to highlight those, the first is, and to give you a little bit of background, the operator, AKA, has ownership of those 2 towers. The east tower is being utilized, they're unfurnished units, and they're being rented typically with an annual lease, and those are starting to be leased up as we speak, and have been starting to be occupied. And then the west tower, which is the subject piece of property that's before you tonight, is being utilized in a manner where people are renting those furnished units for more than 30 days. So while the appellants would argue that they're being utilized in a manner that's consistent with our zoning ordinance for dwelling units, the city ultimately had determined in the zoning ordinance interpretation that the building is being operated as a hotel. Perhaps not the same as hotels in the rest of West Hollywood, but I think extended stay hotel kind of gives you a good idea of the type of operation that's happening. Further, those units are not being rented on a long-term basis, and we'll delve into that a little bit. Additionally, they are in violation of their development agreement by operating in such a manner that's not consistent with dwelling units and is a hotel. And that this use and this operation was not necessarily contemplated in the environmental impact report, which essentially laid out all of the potential impacts of the project on certain key factors in the environment. And ultimately, when it was determined that this project would have impacts to the environment that could not be mitigated to a less than significant impact, there was also a statement of overriding considerations, which ultimately allowed for the project to move forward even with those impacts. Kind of all of this plays into a key piece that's highlighted throughout all of these different documents, which is that we have a serious housing problem in our community, in the region, in this country, in the world. And essentially the need for long-term housing is kind of peppered throughout all of our documents, our general plan, the Sunset Specific Plan, and this use and operation is not supporting that need for long-term housing. Ultimately, if the zoning ordinance interpretation is upheld, staff will return, and I would say regardless of the outcome, staff will be returning with a zone text amendment to further clarify some of these issues. In a lot of cases, the zoning ordinance is amended in a piecemeal basis to address one particular issue in that moment. And I think as we move forward in time and kind of in this time, we see that land uses aren't necessarily fitting that standard mold anymore. People love the word disruption, and it kind of fits here a little bit in that, we tend to amend the zoning ordinance in response to issues that come up. And this will be one of those cases where we seek to even further clarify, to kind of close any gaps of confusion about what types of uses are allowed and what those uses really are. So kind of getting into a little bit of detail, the use as a hotel, the municipal code defines hotel as a facility with guest rooms or suites provided with or without meals or kitchen facilities, rented to the general public for overnight or other temporary lodging, typically less than 30 days. These units are definitely rented to the general public. You can go online, you can book a unit. It will request that you do so for 30 or more days, but anyone can go online and put their credit card in, and the unit is booked. Ultimately, I believe there's additional paperwork that gets signed. There is a lease provided by the appellant that I believe may be required when the person actually checks in. But essentially, these are for temporary lodging. People are not moving into these 30-plus day units and establishing residency. They're not necessarily coming in and changing their voter registration. They're not getting their mail there. This is truly temporary lodging for people. And it's not a question of whether we need this use in general in the city, because that's neither here nor there for this conversation. These are not for long-term stays. Again, guests aren't establishing residency in any way. And, typically less than 30 days in that definition does allow for more than 30 days, which we are seeing in this case. So again, all of that leads to, this building being used as an extended stay hotel. I think the appellant lays out a number of arguments that gets into a lot of detail. We have a number of website printouts for you. I'll spare you. You can ask questions if you have any. But I did want to note that there is a front desk when you walk into the building, and there's housekeeping and a room service type services available. So the next key argument that's laid out in the zoning ordinance interpretation, also addressed in the staff report, is that the use is not long-term. Kind of getting back to the holes in our zoning ordinance, this is why we have interpretations. Sometimes there isn't direct clarity of definitions or specific provisions, and the code says that to provide that clarity, a zoning ordinance interpretation would be issued. So I'll just go through a few definitions that start to get us towards kind of the understanding of what is a long-term basis, what is a short-term basis. We don't have those specific definitions laid out, but we have them mentioned in other definitions, and again, that's at this point, a way for us to kind of narrow this focus. So dwelling units, dwelling unit or housing unit, a room or group of internally connected rooms that have sleeping, cooking, eating, and sanitation facilities, but not more than one kitchen, which constitutes an independent housekeeping unit occupied or intended for one household on a long-term basis. Again, not much more information than that for dwelling unit, but we know that it is for long-term. Then we have a definition about transitional housing. Again, this is not transitional housing, nor was it approved for it. We're not saying that they're using it as transitional housing. Transitional housing is typically intended for occupancy by homeless families or people that are transitioning to permanent housing. Typically, they need public assistance. But it does talk about, it highlights the shall be no less than 6 months. So this is transitional housing that's still not, it's still temporary, but it needs to be more than 6 months. Then we have the definition of emergency shelter. This is also short-term, and it's limited to 6 months or less. So we start kind of seeing these timeframes being identified in the code that start to kind of help funnel us into what we understand as short-term versus long-term. Then we also have corporate housing, and this came up a number of times with the appellants in some of their correspondence to the Planning Commission, and there was a corporate housing ordinance that was enacted recently. It technically would not apply, but again, gives us an understanding of how the code is thinking about the short-term versus long-term. There are kind of two things that make something corporate housing, and one is that it's temporary, and that it's not being intended to use as your long-term unit. It's not intended to be their domicile, and that you haven't entered into a written lease agreement for at least 1 year. And then the second piece relating it directly to corporate housing is that the entity is a business entity that is leasing the space. So again, it talks about you're either, not intending to use it as your long-term residence, you're not registering to vote, you're not getting your mail there, or you're not signing a one-year lease. So that kind of gave some flexibility that, some people have houses all over the world. They have 6 apartments throughout the country, for example. So they may not consider it their permanent residence, year-round, but they're signing a one-year lease. And so ultimately, in combining all of these definitions, it really led us to the question of what is long-term. And ultimately, the director determined that in the zoning ordinance interpretation, that long-term is 1 year. So again, as I stated previously, staff will return with a zone text amendment that will further clarify, I would assume, a number of definitions, as well as add some new definitions to the zoning ordinance. Then there's the development agreement. This is a fairly lengthy document that, I don't want to get too much into it, but essentially the development agreement is the legal instrument that allowed this development to happen. And there are an extensive number of places where they reference the 2 residential buildings and the number of residential units that would be in these buildings. So it talks about 2 9-story residential condominium buildings. Again, this was from prior to the allowance of apartments. But I did also want to note that the development agreement references the FAR, the floor area ratio of the middle parcel being 3.25, and also references that the Sunset Specific Plan would allow an FAR of 2.75 with a density bonus of 0.5 for residential uses. And as you know, density bonuses are only afforded to projects that are truly residential in nature. So it was understood throughout all of this that those residential dwelling units would be utilized for long-term stay. And we'll kind of go through a few more mentions of that, although this is not an exhaustive list by any means. Again, there's reference to the condominium buildings containing a maximum of 190 residential units, which is the number of units that they have. And then this specific section, 334, talks about no less than 10% of the market rate units would be affordable housing on site, which have been agreed upon in an affordable housing agreement with the city. There are 10% of the units, of the market units, which total 17 units, are affordable on site. And then the remainder, the other 10% of that requirement, was handled through a fee in lieu payment by the original applicants. So again, affordable housing isn't required for units that are not dwelling units. And again, this kind of just lends to the argument that the intention of these units were for long-term stay, for market units that ultimately would help solve some of our housing problems. Again, this is the code section the section from the development agreement that talks about affordable housing requirements on the site. I'll spare you a little bit more of that. And then there's also a lot of mention about the mixed use component of the project in recognition of the provisions of the Sunset Specific Plan to encourage residential unit uses on commercial properties and to increase the city's housing stock. The city approves the combination of commercial and residential units to be constructed on the middle parcel. Such developments meet the goals of the Sunset Specific Plan. And one item I did also want to point out in the development agreement is the requirement of how you can change the development agreement. So if someone wanted to come in and change the uses that are allowed on the site and specifically where those are, particularly in this case, it was broken down by each parcel, east, middle, and west. There are some things that would constitute a minor change that could be administratively approved, and then everything else gets kicked up to council. It goes to Planning Commission for recommendation, and then to council for final approval, the same way you approved the original entitlement. And so ultimately there is one section in, it's always written in an interesting way. A change to the project approval shall not be deemed minor and thus major and going to Planning Commission and Council if you alter the permitted uses of the property as a whole. So ultimately, if there was to be a change of use in this way, we would ultimately want to amend that development agreement or go through the process to do so. Then there's the environmental impacts report. ultimately, this report, as I stated, said that there were a number of areas where there were greater than significant impacts to the environment that could not be mitigated to a less than significant level. And the project essentially was analyzed with 190 dwelling units. It's a very different scenario to evaluate a project with additional hotel rooms. Certainly there is also a hotel on the east parcel, but separately the middle parcel was evaluated with 190 dwelling units. And I did want to point out one mitigation measure, H39, and I believe it's also identified as another mitigation measure with the same language. The owner shall comply with West Hollywood Municipal Code Section 140810, which requires that all high-rise occupants receive annual instruction on procedures to be followed in the event of fire, earthquake, or other emergency. Instruction for all new occupants shall occur within 14 days of their assuming occupancy of the building. So, just looking at this at face value, if someone was intending to rent the units for 30 days or more, this probably is a mitigation measure that really wouldn't work because you wouldn't be instructing people on an annual basis, because ultimately a building with 31-day stays has extensive turnover. And so this isn't necessarily something that would be keyed into a project that had that type of operational aspect related to it. In one of your attachments, there's also a lengthy list, I believe it's quite a number of pages, so thank you for reading it, of all of the mentions of the essential need for increased housing stock in the city, and any mention of dwelling units in the EIR and its additional attachments. So I just wanted to point out a few, and I think the key piece is the objectives have therefore been identified by the applicant for the proposed project to provide needed housing stock for the city of West Hollywood. So, in this case, we need long-term housing, and that gets into more detail as well. Increasing the city's housing stock is truly for a long-term tenancy and not for a hotel-type space. They also touch upon the general plan goals and objectives that would be implemented in the development of the proposed project at the time. And it was really to encourage the private sector to develop housing, including the production of housing on underutilized land, promote the production of housing. Again, you see the theme here. So, I know there's a number of arguments that are laid out, and we address a lot of the appellant's arguments in the staff report. And rather than go through those in detail, I know the appellant is here to present those as well. I really just wanted to touch upon those really key items and stress that the city approved this project as part of one of the many solutions to our long-term housing problem and the housing crisis that exists in this community. And the use that's on site today does not support that need for long-term housing. So again, staff is recommending that you uphold the zoning ordinance interpretation. And again, we'll be back with zoning text amendments. So if you have any questions, I am available. Thank you.
Commissioner, questions of staff?
Thank you. Rachel, just in the last 48 hours, it seems, we received 2 supplemental documents to the initial appeal. And just tonight, we received the development agreements collectively, I suppose. This is all of the development agreements combined, or the sections of the development agreements combined?
That's the restated development agreement from 2005, and then I also included the change in 2012. All other unrelated changes weren't included in your packets.
And then, in addition to these last-minute submissions, there were a few letters, the he said, she said type of letters. We obviously have not had the opportunity to read all this. And I think your oral report was quite broad and quite probably inclusive. But when Lauren tells us a few minutes ago that the Melrose Triangle case took 5 years to get before one court, I don't think it came before that court without the people who were supposed to make decisions on it having time to read all the materials. Do we have to make a final decision today, or can we continue this final decision after hearing Rachel's analysis, after hearing the appellant's arguments and some public comments, continue this until we have a chance to read the documentation.
Certainly, you are open to continuing to a later date if you so choose. Ultimately, I think our understanding was that the key items were provided to you in a timely manner. I mean, if you need more time to go through it, we absolutely can continue it.
It was 25 after 6.
Right. I think, our concern is that they're continuing to operate illegally as we wait, but absolutely, it is well within your right to continue this as you see fit.
Well, our concern, at least my concern, is if they're operating illegally, they shouldn't be. But nevertheless, if there are all these documents in the record, to make a decision, I would like to have a chance to read them. And I think that's only reasonable. I could see no reason not to include the development agreements in the packet, but they weren't. If somebody wanted to submit some supplemental arguments, they should have been done, I think, with more time than the 48 hours over the email to submit these things. There's going to be several steps to this process. This is not the last step. This is the first step. The council is the next step, and I'm sure the courts are the step after that. So the question is there a proper process when the people that are asked to either accept your position or the appellant's position tonight have done so without having read everything that's been submitted?
In other words, can we keep, after we hear the appellant's position and some comments from public, can we keep the public hearing open and continue it on so that we can, if the commission believes that we need more time? I felt at a disadvantage looking at everything because I didn't have a copy of the development agreement, and I think that there's certain parts of the development agreement which are really necessary for us to understand and to review. And so that's a concern that I have. But Lauren, can we keep it open at that point?
Well, I think you're asking two separate questions. One is everyone prepared to hear the item now? And then two is, after you've heard everything, are you prepared to make a decision tonight? I think Rachel did a pretty good job of pointing to the relevant places in the supplemental documents that were provided, such that you may not need to read all 200 pages because there's only a few provisions in the development agreement that might relate to whether it's to what the city and to what the parties' expectations were in the development agreement. But ultimately, it's up to the commission, and if a majority of the commission doesn't feel prepared to make a decision, we can talk about that.
Also,
So should we sort of check with all the commissioners to see whether they want to proceed? I mean, would it be appropriate to stop at this point, or should we go ahead?
From a legal perspective, I would probably prefer not even opening the public hearing, because then you have the risk of people talking in between the two meetings and taking evidence outside of the hearing, and so it creates a difficulty when you open it and then continue it to the next meeting. But maybe what you'll hear tonight from staff and from the applicant will answer all your questions, and you will feel satisfied.
well, I don't think it can answer all the questions, because when you have in front of you two supplements to the application for appeal, or to the appeal, and then you have the development agreements, some of which may be totally irrelevant, but some of which may not be totally irrelevant. There's a reason that these documents are in the record and should be in the record, and part of the reason is so that the people who are voting on whether the appeal is to be upheld or denied lies within some of this printed material. And I also have one more question while you're pondering that, which doesn't have anything to do with the issue at hand, but it has to do with this whole project in general. I noticed in the last several weeks the triangular billboards that were very much flush and touching the buildings have now jumped off the buildings and are over the sidewalk. Do we know how that happened?
They've always overhung over the sidewalk slightly. I
They
don't know
have
the
been
exact.
somewhat over the sidewalk, but they have not been detached from the buildings.
They were always detached. There was a space between, and they needed to have that
Like
space
there is now.
maintained. It hasn't changed. The structural portions of the billboard have not changed since January of 2017, when the certificate of occupancy was issued.
Yeah, they have. I drive by them several times a day. And
We can certainly look into it.
I would think that that should be looked into too, as to exactly how did that happen and what was the reason for it?
If it happened, somebody needs to go and check.
I don't believe that they have changed, having gone by on a very regular basis as well, but I will absolutely go out and
For several
measure.
years, having seen them flush to the building, and now they're like this away from the building. And that's not to scale, but it's just to find what in my visual occurrence happened.
We can confirm. I believe we actually shot some survey points in January of 2017, so we can do a comparison. We know exactly where those billboards were when we approved them.
And also, there's the new awnings over the commercial.
And those were approved as part of development permits for the commercial spaces for both Fred Siegel and
And had I
the West
had
Tower.
this before 6:25, I would have known that, right?
I don't know that those items are in your packet.
Well, you said they were part of the development agreement.
No, a development permit. So there were a number of permits issued after the certificate of occupancy for the core and shell that contributed to the tenant improvements, including some changes to the exterior for
So
Fred
are
Siegel.
those post-agreement development permits included anywhere in here?
No, frankly, they're not really relevant to this issue, and I didn't want to conflate the conversation with outside issues. I am happy to provide any of those to you.
Well, I think at this particular point, everything should be provided, because...
Well, we'll need, it's basically half of a room. So, I mean, being totally honest, we can certainly provide you with whatever documents that you'd like, but this is
Then
a
a
very
synopsis.
lengthy record.
Then a synopsis or some kind of a synchronization of what they contain, which then, if the appellant disagrees with that synopsis, they can have a response to. But all of that should be in the context of time, that the 7 of us, or 6 today, 7 next time, should have the ability to just kind of filter.
Rachel, I think one of our other commissioners would like to address staff.
Thank you. As regards the billboard question, maybe we can ask the director to report on that at our next meeting or something. It's not, I know it's part of this project, but it's not part of what we're here to hear tonight. I'm a little conflicted about continuing this. I too just received the link that you sent earlier, Rachel, with the development agreement, and did not have kind of time to use my highlighter to go through it. But I want to be respectful of everyone in the audience tonight who came out, and also to your point that, we would like to move this along in the interest of, coming to a conclusion. My question for you, and I don't know if it's better for you or for City Attorney's Office, for Lauren, is this going to council after it comes to us as a recommendation we're making to council, or is this a hearing that we are making outright?
So you are making a decision. So
Okay.
the zoning ordinance interpretation was issued, the appellant appealed that decision, and so you're making a brand-new decision on a zoning ordinance interpretation or upholding the appeal decision.
Okay.
Or the appeal, rather. Should your decision be appealed, it would then go on to city council for
That's what I
another
thought.
de novo hearing.
Okay, I just want to make sure that was asked and stated for the public record. I'm interested to hear what our my fellow commissioners have to say on this.
Do you have any opinion one way or another? Down there? Disclosures. Huh? We could do some disclosures first, if that's helpful. Go ahead. Do the disclosures. If you have a comment, then this is the time to do it. Before we proceed.
I had 2 conversations with the
I don't-
applicants. I had 2 conversations with the applicants' representatives today.
with regard to what was in the original packet?
In regards to the staff report.
I had a phone call with Mr. Seymour, the applicant's representative, and discussed only items that are contained in the staff report. As far as hearing this, and I hope my boss is not watching our planning commission meeting, but I had a fairly slow afternoon today, so I was able to, I was actually able to go through these documents online to my satisfaction, so I'm prepared to move forward.
Thank you.
I had,
Disclosure?
Oh, sorry.
Go ahead.
yeah, I had a meeting with Mr. Green, one of the representatives of the appellant, and discussed the matter as outlined in the staff report.
Commissioner.
I had a phone conversation with Mr. Seymour, the applicant's representative, yesterday, and we contained only what was discussed in the staff report.
I visited the property today, and I have not spoken to any of the applicants.
And I did have an opportunity to speak on the telephone with Mr. Seymour, the applicant's representative, and we spoke of issues that were contained in the staff report only. So, does anybody else have an opinion about whether to go forward, or are you feeling comfortable and prepared
I'm
to
too
move forward?
of mixed opinions. I would agree with Commissioner Altschul. I find it very disconcerting to receive a lot of material at the last minute. I did not have a lazy afternoon. I would have liked to have. And so I received this pretty much as I was walking out the door in an email, and have not had an opportunity to review the full development agreement. And at the same time, I feel like, yes, Rachel's done a good job of pointing out the relevant components of it. But having said that, to do our job well, we might, upon review, find other components of the development agreement that might have an impact on this decision. So I am very conflicted and want to honor everyone's time tonight, because there's nothing worse than sitting around here and then having nothing happen. So I'm open to hear what Commissioner Caballero has to say.
I feel exactly the same way you do.
Which is specifically?
Conflicted.
You're conflicted.
What would staff and the city attorney's recommendation be? I think I'm going to ask you to repeat what you just said, but can you help guide us here?
I'll let Lauren provide any legal guidance, but if the commission doesn't feel comfortable, we could probably easily continue this to a date certain to April 19th. That would give staff time to put together any other documents that the Planning Commission requests, and to get that properly in the packet so that it is out to the public and to the commission with an adequate amount of time. But April 5th also is a possibility. It just may not give staff as much time to gather any other documents and kind of do a summary that was requested. So those are available.
I think that to protect the record, because in my opinion, this is obviously, to me anyway, going to go to the courts. It's not going to get resolved within the administrative process. I think the court is not going to be happy hearing that people voted on something that didn't include having time to read.
And more importantly, the public has not had a chance to read. We all received an email with this material, but it was not part of the published agenda and was not part of the public record. And the fact that we all got this on our desks as we sat down this evening, the public has not received this.
Exactly.
And I think in light of the very important need for transparency, I think that that is an important consideration, and we make our decision. And having said that, I would move to continue this.
I would say too,
I'll second it.
if we did choose to continue this, it's not so much my concern that we don't have the materials that we need, just that we have time to review them. That's all. That's kind of the crux of my ethical or moral dilemma here.
I specifically wanted to see the development agreement, and so I didn't get to see it until I got here tonight, and I didn't really have a chance to read the pertinent sections that I was thinking about that might help me deal with these issues. And so I would like an opportunity to do that. I feel, I'm sorry to have all people in the, including the appellant. I'm sure that they all here, there's lawyers here that came from maybe a long distance, and I know it's an issue. Lauren, would it be appropriate to hear from them about just the continuance?
Just the issue on continuance, I think that's a fair.
I would like to hear if there's somebody representative, but only on the issue of continuing the matter.
I understand the limitation, Commissioner and Chair. My name is Stephen Ellis. I'm an attorney for the appellants. We're here. We'd like to be heard on the merits tonight. We understand that there's material that the commissioners would like to review, and if the commission is not prepared to take a final vote, we understand that. We filed our appeal back in December. 3 months have gone by. We are very eager to get this resolved, and we understand that there may very well, likely will be further steps before we get a final resolution of this. And so we would like the opportunity to be heard on the merits and move this along as quickly as possible. Of course, we're very respectful of the commission, and ultimately, if the commission feels they need more time, of course, we're not going to disagree with that. That's a decision that we will.
When did you file the amendments to your appeal?
We filed the initial appeal back in December. We filed an additional letter on March 1st, and then we have supplemented as the record has continued to be filled in. We have filed a couple of additional very short letters, 1 and 2 page letters.
When were they filed?
The last one was filed last week, and one was submitted on, I want to say, Monday afternoon.
So one was last week and one was this week?
Yes, those were very short letters, 1 to 2 pages long.
I'd like to make a point for the record that I did ask for a copy of this development agreement, I believe on Monday via email, because I knew it was a long and lengthy document that was going to take some time to digest, but I did not receive it until now. And so that and the fact that the applicant has just said that they sent a letter on Monday, which we just got now, is problematic for me. And back to the transparency issue, I think this really needs to be continued.
So I believe you made a motion to
I did.
continue it to either of the 2 dates that are available, April 5th or April 19th. I seconded the motion. Lauren?
I was going to say, let's maybe, if we can choose a date certain, that would probably
April
be
5th?
And I would think that if we could can we put in that motion a final date for any documents that wish to be considered to be filed, to be received?
I personally would note that April 19th would probably be more productive, and as much as the April 5th has 2 fairly meaty items on the calendar, and so from a workload perspective, I would say the 19th would be a better date.
And staff would agree on that.
And also, I would then say, we require that any documents that are to be filed to be considered must be submitted to the city by April 9th.
And on both sides, staff or the appellant?
Yes.
So we have a time to consider it.
May I be heard further, or is my time expired?
Yes, as to the issue of continuance only.
Yes, I do. We do want to move this forward. The earliest possible date is the date we would prefer. We're prepared to give our presentation today, and I do think that in many, many ways, after you hear my substantive presentation, you realize that many of the issues regarding the development agreement really do fall out of the case. I don't want to exceed what you've asked me to talk about. I'm still talking about the continuance.
Mr. Ellis, you're arguing.
I apologize. I'm trying not to.
Let me take a look. I'm looking at April 5th, and those are 2 projects, 2 items that are put on our calendar that really have to do with training that could possibly be moved to another date, and we could, I think that considering that They want to move forward, April 5th?
Those are not training.
Am I looking at the wrong
We're
one?
talking about projects spanning residential and commercial
Yeah,
properties.
I understand.
No, the training is another date.
It's still the same
That's the
thing.
19th.
Still the same thing.
There's no training on this one. This is from today. That's from March 1st.
Okay, sorry. I still would prefer myself that we move it as soon as possible. I think it's only a fair thing to do. That's my view.
So is the motion for the 19th or the 5th?
I would, my motion is for the 19th, unless staff is willing to rearrange the calendar and move the other items to the 19th.
We can always move a training item, that's not a problem. I think our concern is just more with packet deadlines. Check with our secretary, what would the deadline be for the April 5th meeting, David?
This is today.
We have until Monday, March 26th to get everything into the packet.
And if we
Which
had
is a
10-day
holiday.
Which is a holiday, so it'd be Tuesday.
And if we had a 10-day requirement for everything to be filed prior to the hearing date, that would be day after tomorrow.
Correct.
Yeah, so I think April 19th would be a more appropriate date to continue to a date certain.
I will, that is my motion, the 19th.
That's the motion, all right. Any other comments by commissioners? Nope.
And the motion passes 4 ayes, 2 noes to continue to Thursday, April 19th.
I do
Thank you.
apologize to the appellant for this, but I think it's really in the interest of everybody that we do a fair hearing and have all the information to do that.
I don't think apologies are necessary to the appellant because the appellant filed, even though they may have been short, supplemental documents to his appeal within the last 2 weeks.
So moving on to...
We apologize to the public.
I apologize to the public and to the appellant. That's my view, but it's my apology. Thank you to everyone that was sitting here and planning to hear it, including staff. So thank you, and we move on now to the item 10B, 10C, and 10D. They are all resolutions that would require the Planning Commission to adopt approving a subdivision permit. My understanding is we could consider them independently one at a time, or we could consider all of them at the same time. Can we hear a staff report on this issue?
Chair, my understanding is that we can even forego a staff report unless we need it and consider them all at once, which would be my preference.
That's if there are no
As long as there are no
questions.
speakers.
And there are no public speakers on these
Public
items.
speakers. And are there any questions of staff on the part of?
Yes, I do have some questions.
Okay.
Okay.
Because I'm very confused. I'm reading the staff report. The first project says it's a 3-unit apartment moving to a condo, but then on page 6, it's talking about a 5,200 square foot of land area that allows for a maximum construction of 8 dwelling units in an R2 zone, but R2 for 5,200 square feet is 3 units. And then it says it's sufficient area to support the 7-unit, but then when I look to the resolution, it's back to the 3 units. What is correct?
So there, on page 4 of the staff report for 634 Huntley and 1236 Spalding, it does refer to 7 units. That was a typo, my apologies, from the 1236 Fairfax. So everything in the resolution is correct. It's just that typo on page 4 of the staff report.
For each of the projects, there was
Or
it was
in
a typo.
in two of them.
For Spalding and for Huntley?
Yeah.
Correct.
Not for Fairfax?
Correct.
Okay.
Okay. So then the other question I have, and this perhaps is more for legal. A number of months ago, Commissioner Bass made a request, and we've made it a part of every conditional, every resolution since then, that all construction parking be off the city streets. But when I read these resolutions written by staff that didn't go through the commission, it does not include that component. And so my first question is, what's our ability to make sure that that gets included? And is there a particular reason that staff has not included that in their resolution, in as much as it's the same sort of projects?
I don't think that issue is before us tonight, but I hear what you're saying.
That's my question of legal.
That condition was in the original resolution for the project, the development permit project that was staff approved.
So
That's why it wasn't in here, because we didn't want to duplicate the same conditions.
the additional construction provisions here that overlap,
Some of them overlap just because they were, the projects were approved a couple years ago, and we do have new conditions. So these are conditions that coincide with the development permit.
okay, so all of those original
Yes, they're all
resolutions
included in the
include
development.
that
Right.
off-site parking. Thank you.
Correct.
That policy won't change even though the Planning Commission is not reviewing those permits.
Thank you. So with that, and for the public, a while back, we had a matter before our commission about projects that don't require coming to Planning Commission, but the track maps by state law do require approval by Planning Commission. And so these three projects were already approved at staff level, but the track maps are what we're looking at today. And we're required by state law to approve them. So I think that,
I guess for matter of procedure, legal, should we have separate votes for each one because they're separate track maps?
I think the record can reflect that you approved all of them in one motion.
so if there's a motion, unless somebody has a comment or at this time?
And to be clear, I'm moving all three, there is staff recommendation on all three items.
And the motion passes unanimously, noting Commissioner Guy absent.
Thank you. There is a new business item. Staff is asking us to appoint someone as to participate in a working group on green building program. And I have asked Commissioner Hopengardner to be the person to represent our commission, and she's accepted. And I asked Commissioner Bass if he would be the alternate, and he has accepted that, so those will be the appointments. Thank you for your willingness to serve.
Thank you for your
Number
faith.
12, going on to number 12, unfinished business, there is none. We have excluded consent calendar, none. A planning manager's update,
None for this evening.
none for this evening. Do we have any public speakers at this time?
There are no public speakers.
No public speakers at this time. Any items from commissioners? Yes?
Yeah, I'd like to get from the staff a clear explanation of how one achieves exemplary design status on our projects. We have several projects in the pipeline right now, some of which have exemplary design, which I question that status, and some which don't, which I think deserve the status. So at some point, I'd like to have a breakdown of how you achieve exemplary design status.
Yeah, we would be happy to do that. And in fact, we have our commission training on architecture by Gwen Pugh. So that'll be one of the topics that he addresses. So I'm thinking it might be in May, but maybe we can even move that up a meeting. So we will check with him and then we'll get back with you.
Great, thank you.
Thank you. Next item is adjournment. Oh, excuse me. I didn't know. Thank you.
I just have one. It's kind of fun. It's not really planning related, but I would like to wish a very happy birthday to our Supreme Court Justice, Ruth Bader Ginsburg, in the spirit of all things, Ruth Bader Ginsburg, in the spirit of,
Oh, yes.
of all things judicial. Thanks, Ruth, for your service.
And I'd like to, thank you, that's good, great. And I'd like to just remind everybody that on Sunday, we're going to have the LA Marathon moving through our city. So those of you who want to go somewhere, do it Saturday or whenever, or figure another way in and out of your, if you're affected by the closures, which will be on Santa Monica Boulevard partly, Sunset Boulevard, from downtown all the way to Doheny, I believe. No? To San Vicente?
Doheny to the ocean.
Sunset down to San Vicente to Santa Monica to Doheny.
No, it is not.
Yeah.
No, it is not.
Land
Sunset
supplies.
is closed.
From Doheny West.
From Doheny West,
And
yeah.
then-
And
yeah.
then from Doheny on,
In Hollywood, it's closed, but not here.
I think it is closed.
Sunset to San Vicente to Santa Monica to
Anybody
Doheny.
know? Because I saw the barriers up on Sunset today, and last year we were closed. Sunset to San Vicente, right.
Chair, I have an item that
Yes.
I'd like, another fun item that I'd like to bring the public's attention to. The city recently put out an RFP for parklet designs. And I, for one, am very excited about this idea, about the ability to create parklets, and I believe it's, I think, 7 parklets in the city. You can put together your own team to come up with a design to essentially take over 1 to 3 parking spaces on some of our major thoroughways and create a parklet. And the city will give a $25,000 grant to those teams working on that. You can look to speaking with the chamber and other members of the community about fundraising for any additional costs. But I think it's a really fun and exciting idea, and I think everybody should know about. Thank you.
Thank you. For those of you who are confused, since Commissioner Altschuld and I are in disagreement over this, you can go to the website, the city website, and it will be specific about what the closures are, so just be warned.
I would like to say something.
Yes.
Jean Dobrin has been in the hospital. It's not life-threatening, and she probably will be released tomorrow, but we wish her speedy recovery.
Yes.
And Chair?
Yes.
Just before we adjourn, on a going down that serious note, I would like to ask if the Planning Commission would be all right adjourning tonight's meeting in memory of Carmen Gloria Duran, the mother of our Mayor Pro Tem.
Thank you very much. And we can do that, even though we didn't announce it at the beginning, but we'll do it now since we haven't adjourned yet. Thank you very much for that. And we wish our councilman well. So we will adjourn now the Planning Commission to the next regularly scheduled meeting, which is Thursday, April 5th at 6:30 p.m. here in council chambers. Thank you very much, everybody. Good night.